Further hearing in the appeal, Queen on the application of Sainsbury Supermarkets Limited against Wolverhampton City Council and Millwall.
Yes, we have until 4:30.
Yes, we're all aware of that, so we get going straight away. I was making some submissions about the nature of the power in section 226 and the well-being considerations that are brought in by subsection 1A, and my next submission is that, my Lords, the well-being benefits that could arise under subsection 1A are not confined to planning matters only. The words, my Lords, tab 1 of the first volume of the authorities bundle in subsection 1 big A, economic promotion or improvement of economic well-being, social well-being, environmental well-being, well, those concepts plainly I would submit are wide and could encompass non-planning well-being benefits such as health or educational benefits. Could I just go back, I think, to the question of, because Mr. Lockhart-Mummery touched on this yesterday, the question of the changes that were made between the old version of the section and the new section. Obviously, I think I can deal with this quite briefly, and certainly intend to do so. So far as tab 2, my Lords, so far as subsection 2261 little a is concerned, known friends already pointed out the difference, suitable for and required in order to secure essentially became if the authority think the acquisition will facilitate. There were other changes too, but that's the nub of it. And plainly that was intended to be and is a somewhat less stringent test. The old section 226 subsection 2, as your Lordships have seen, listed 3 planning matters to which regard had to be had. The development plan, whether there was planning permission in force, and any other material planning considerations. And plainly, subparagraphs A and C of the old subsection 2 mirrored very closely the requirements of section 70, subsection 2 of the same Act, which, as your Lordships are obviously entirely aware, applies to the determination of planning applications. The section 70, subsection 2 is at tab 10. Duty in determining planning applications to have regard to 2 things: the provision of the development plan, so far as material, see old subsection 2A of section 226. Secondly, and to any other material considerations, see subparagraph C of subsection 2 of the old section.
I suppose the new subsection 1A well-being matters could have been material.
Yes.
I mean, that seems fairly straightforward.
My Lord, I would entirely accept that. Equally, if I may say so, subsection 2, I just want to point out that subsection 2 of the old section was replaced by subsection 1A. Parliament could have added subsection 1A to subsection 2, but it didn't. The old subsection 2 was not retained, it went. Now, that's not to say, in a sense, the converse of my Lord's remark a moment ago, that the matters these days that are identified in the old subsection 2, the planning matters, are no longer relevant to the question of whether or not to make or to confirm a compulsory purchase order, but they are no longer matters that are required by the statute to be taken into account. I mean, it's the case that in many Section 226 CPOs, since the amendment, those matters remain very important to the justification for a Section 226 compulsory purchase order. They remain very important to the justification for the order in the public interest, quite plainly. But I respectfully submit the fact that Section 226(2) was, as it were, done away with altogether, underlines that what Parliament intended to achieve through the amendments to Section 226 was a power that actually could be exercised in a wider range of circumstances than had previously been the case. The source of the amendments, as your lordships again have seen, to section 226 was section 2 of the Local Government Act 2000. If I might take your lordships back to that, please, tab 3 of the Authorities Bundle, volume 1. And one can see page 5 at the bottom, section 2.
Where have we gone?
I'm so sorry, tab 3, my lord, in the Authorities Bundle, section 2 of the 2000 Act. I hope, at the bottom of page 5. Yes. One can see at a glance that it's subsection 1 of section 2 that's in substance been transposed or imported into section 226(1) big A. I just draw attention to one, however minor but potentially significant difference between the words of section 2(1) and those that we find in 226(1) big A. Section 2(1), your lordships will see, confers power on local authorities to do anything which they consider is likely to achieve any one or more of the following objects. Subsection 1 big A of section 226 requires an authority to think that the development which will be facilitated by the exercise of their CPO powers is likely to contribute to the achievement of those objects. The words contribute to effectively have been added in the transmission of section 2 subsection 1 through to section 226(1)A, and I suspect nothing very much will turn on that. However, it is our submission that subsection 1A of section 226 is therefore expressed in slightly wider terms.
Contribute wouldn't make any sense in the 2000 Act, would it?
My lord, with respect, Lord, I think it would, wouldn't it? It could have read, every local authority to have power to do anything which they consider is likely to contribute to the achievement of any more or one or more of the following objects. I mean, obviously you'd have to change achieve to achievement.
But I must say, the idea that you couldn't justify doing something because it's merely like to make a contribution to achieving an object.
I'm not...
I suppose if you're beating the air and it'll never happen, you better not spend public money on it.
No. I'm not, as I hope I've made, I'm not suggesting that that's a very significant difference. I'm simply pointing out there is a difference in the wording. It must have been done for a reason, and if anything, therefore, the 1A test is slightly, if you like, less stringent than the section 2 subsection 1 test.
Well, they are different things, because the exercise of the section 226 power is a step, as it were, along the route, whereas the other section is describing the route that is to be taken. You've got your plan for well-being, and you take various steps to achieve it, and this would be one, and that's a contribution to the overall aim. I mean,
my lord, I don't press the point any further. Let me move on. My lord, going back to 1 big A, obviously, I've already made the obvious submission, I suppose, that the range of matters that can be taken into account under 1 big A in section 226 is limited by the words at the end of each of the sub-paragraphs of their area. Just to point out that that's not the case in section 2, because subsection 5 of section 2, which is on page 6 in tab 3, says that the power under subsection 1 is power for a local authority to do anything in relation to or for benefit of any person or area situated outside their area if they consider it likely to achieve one or more of the objects in that subsection. So, obviously, the 226 power does not extend beyond the authority's area. So that part of section 2 wasn't taken across into section 226. The reference was made, I think, not in his oral submission, but in the appellant's case. That is not in the Learned Premise Lockhart Mummy's oral submission, but it was in the appellant's case. Section 3 at tab 3, still of the Local Government Act of 2000. As we made reference to in the oral submission, doubt your lordships want me to deal with it, and I won't take up time unless your lordships would like me to. It's our submission that that we have nothing to do with this case at all. It says subsection 1 of section 2.1 power doesn't enable the local authority to do anything which they are unable to do by virtue of any prohibition, restriction, or limitation on their power which is contained in any enactment.
Yes.
But there is in our submission no such prohibition, restriction, or limitation in section 226. So it's a matter of constraint.
There's no issue but that the RHS development would fall within A, B and C. The issue is the nexus it must have with the development.
Yes, well let me absolutely not. I'm going to deal with that in my submission. Section 70 subsection, I'm going to come to some of the cases in a moment, but section 70 subsection 2, just to return to that thing and how different it is from what similar it is to section 226. It's a development control power. Section 226 obviously is a land attendance power, so they are very, very different in their nature. The contextual difference, so it extends rather further than that, as Lord Justice Sullivan points out in his judgment in the Court of Appeal. I think I can deal with the next section of my submission quite quickly because it was touched on by Dr. Armand yesterday. Under Part 3 of the Act, in which Section 70 appears, headed control over development, the local planning authority to which a planning application is made is the ultimate determining body in essence that the accused can determine the application in appeal, or unless Secretary of State exercises his or her calling powers under Section 77. Calling power used sparingly, but not infrequently. An objector, of course, to the planning application has no right to appeal or against the planning application. Under compulsory purchase legislation, if your lordships have seen for Section 226 CPOs, that is, the order has to be confirmed by the Secretary of State. There is an exception in the Acquisition of Land Act, Section 14, capital A, where the Secretary of State will confirm the order itself, but that only applies where you get any objective consent to that procedure. So in any Section 226 case, whether there are objections or not, and whether there's a public inquiry or not, it will be the Secretary of State who will need to examine the legalities and merits of a compulsory purchase order made by an authority under 226, including whether the statutory requirements have been complied with, procedural matters, notification, publicity, etc. The Secretary of State will have to consider whether the advice in the circular has been followed and whether the considerations set out in the circular have been satisfied. And the Secretary of State will have to decide all in all whether it justifies, the confirmation is justified. The relevant provisions of the Act, including the Acquisition of Land Act, bringing the authorities volume, and I don't need to take your lordships to those. A landowner, any landowner that can touch the statutory objectives has the right to be heard by an inspector appointed by the Secretary of State. A statutory objector such as Sainsbury's could be, if the CPO was made, and has a legal right effectively to ensure the Secretary of State is the ultimate decision maker on that objection in that planning application, and ensure that his objections are heard by an inspector.
How is any of this of any assistance at all to our
Well, it was a
problem?
considerable assistance to the Court of Appeals, and in my respect for submission, it of course doesn't really relate to the question of where the nexus is, but it does set the context for your lordships with respect consideration of what the extent of this power is and
whether it should be subject to, if your lordship's like, probably not a very good way of putting it, but the same constraints as applied to decisions under subsection 2 of section 17. It's like my submission that one cannot, as Lord Justice Sullivan found, simply transfer across, as it were, the cases on section 70 subsection 2 and apply them to section 226. And that's the matter that I want to turn to. I take your point and won't weary your lordship with any more about that. Now, the circular advice in Circular 06 of 04 has largely been put before your lordships. I'm certainly not going to take up time going back to that, but I do invite your lordship's attention if I can just perhaps give reference to paragraph numbers, particularly in the main circular, that is not Appendix A, paragraphs 13 and 14 and 16 to 23. And then in Appendix A, paragraph 2, which your lordships have seen has emphasised the width of powers, through to 11, and then 12 through to 15, which deal with canon matters, and 16, my lords, is important. It's got the 4 matters the Secretary about which the Secretary wants to be satisfied, and confirming all, including 2, tab 31. Tab 31, page 715, volume 2 of the authority. Those matters include, as I was saying, top of page 716 at tab 31. The extent to which those persons contribute to the achievement of the promotion of well-being, that is subsection 1A brought into the circular. 1 plainly relates to planning matters. It relates directly to planning matters. 2 through to 4 do not relate directly to planning matters in quite the same way.
There's no doubt that little a is a general power, and so a large variety of matters may be relevant. Yeah, but the question here is...
All right. I need to get back on track.
Can I put you a scenario, Mr. King? I mean, assume Tesco and Sainsbury's each have, not quite all, but a substantial part of separate plots, but there's only room in the area for one of these stores. And so they're competing for planning permissions, okay?
Yeah.
As I say, they don't actually own the entirety of the sites which they're looking for a planning permission on, but that could be dealt with by CPO in the end. As here, one of them has puts out the temptation of another site, RHS here, okay? Now, in that scenario, when the local authority are deciding which of them should get the planning permission for their site, yes or no, can they have regard to the fringe benefit, as I'll call it?
Yes.
They can.
They can.
Even though it's a planning application.
Yes.
And even though the fringe benefit is not on that or doesn't, so to speak, directly relate to that flat, it's just a fringe benefit in the same terms as here because of a contractual link-up.
But I would say that is a relationship. It all depends, my lord, if I may effectively say so, on what's meant by direct relationship. I do want to look at the authorities on this.
But a little bit ago you said that the authorities weren't helpful, but if you're right, the authorities on section 70 are helpful.
If they're relevant, my lords, there are 2 issues in this case. One is, does this matter fall within subsection 1A, this consideration, this RHS benefit, fall within subsection 1A of section 226? That's our principal submission. Answer, yes, it is, plainly on the face of the statute. Our second submission is that, well, if it doesn't fall within 1A, and this is the basis on which Mr. Justice Elias then was decided the case, is it nevertheless a matter which, under normal public authority would be entitled to take into account. We also say yes in answer to that question. And I am going to come to it very shortly, I promise, but what I'm going to say about those cases is if any assistance is to be derived from any of them, then actually when you look to see what they really say, Tesco ends up by saying there has to be, the Lord Keith's words, if a benefit has nothing to do with its providers, that planning context with the application, then it's not legitimate. And I shall show you, Lordships, how the Newbury tests have not been followed in terms of material considerations in a planning commission. Are there two stages or are there possibly three? First stage, is it within 1A? And if it is within 1A, then as I understand it, it's conceded that it's a relevant consideration. If it's not within 1A, next question is it something which can properly be considered when making the discretionary decision as to whether to grant a compulsory purchase order? And then is that exactly the same question as what might be the third question, where you've decided in principle it would be a perfectly proper case for a compulsory purchase order, even if you're not allowed to consider this factor in doing so. If you have two competing projects, can you have regard to it? Yes, that may be so. Well, there may be three questions. I entirely understand your Lordship's point. It comes in only when you have a competing. It's certainly our submission that it comes in any event. The fact that it's that this is a competition situation underlines how important it is to have regard to this factor, really. But I can see that your Lordship might look at it in a slightly different way in the way that it was said. Yeah. Could the question arise
in a non-competitive situation?
I mean, you're never going to be considering a contractual link unless there's a competitor.
Well, it could arise and it could be relevant, but it's difficult to see how it would be like to make any difference.
How could it arise?
Well, my Lord, the Brighton case, it may not be quite an answer to your Lordship's question. The Brighton case, which I was going to mention in a moment, was a case in which the planning commission was refused for a housing development in school grounds on the basis that it had adverse amenity impacts. The school grounds also included a listed building in the conservation area, and the inspector on the appeal found that the amenity impacts did not merit the grant, the refusal of the planning commission in an event, but he also the fact that the housing development would pay for improvements and renovation of the listed building. So it was a fact that he took into account and the court held he was entitled to take into account, even though he didn't have to. This was a planning commission case, even though he didn't have to, in order to allow the appeal and grant planning permission. Now that's not, I accept, a direct answer to your question, because it's not a CPA. But the local authority isn't bound to grant a CPO simply because the proposed development will have some beneficial aspect. It's a discretionary matter. And as I understand it, your argument would be that in exercising that discretion, one can have regard to extraneous matters that don't fall within 1A. Well, one can certainly do that as well. Like the planning considerations that arose under the old subsection 2. Regard can be had to, but there's a third choice in this case. The council can make a CPO to facilitate Tesco's, can make a CPO to facilitate Sainsbury's, or it can not make a CPO at all. And that's still a possible outcome, obviously. Can I then try and move on to some of these cases? Yes, I probably don't need to deal with that, actually. The submission has been made which we don't contest. The powers of compulsory acquisition was going to be exercised as a last resort, and following careful scrutiny, that's the Crest case. I just invite your Lordships to note, and I deal with this extremely briefly,
that in press, the Sir Brandon Rees-Williams case, where Lord Denning famously started his judgment, Sir Brandon the matter which the court found that the inspection secretary stated was the CPO case.
Do we have this?
Tab 21, I'm so sorry, my lady. Volume 2, tab 21. I wasn't going to, I had been intending to take your lordship through a little bit more detail, but given the time, and thought about it again. May I just invite attention? I won't do the tab, but at tab 21 in volume 2, at the bottom of page 408, Lord Denning, the Master of Law, his conclusion over the page 400.
Very well represented, that's the problem. Sorry, page what?
I won't. And also...
Page what?
Tab,
No, I got the tab.
Page 408.
408.
408.
Which is French from Secretary of State for Wales. Lord Denning's conclusion at the bottom of 408 going through 409. And then in the judgment of Lord Justice Watkins at page 417. Really starting about a third of the way down the page. And 417. Actually goes down to about 2/3 of the way down the page. I'm drawing attention to this case because, in case it suggested you or lordships think that there's something somehow inherently legitimate about somebody, in this case an objector, of course, in our case, the promoter of the scheme, making an offer to do something, if there's anything inherently, if you think there's something inherently wrong about something being made a relevant consideration by the fact that somebody makes an offer in relation to it. That's the only reason I refer to this case. The consider, if I can just very briefly try and summarise this, the consideration that the CPO in this case, in relation to Sir Brandon Rees-Williams' plot, was confirmed on the basis that the two alternative sites that he was going to that he had offered for this sewage works were going to be more costly to develop than it would be to construct the sewage works on the site that was in the CPO. So Brandon Rees-Williams said it won't be, because if you acquire the land in the CPO, I'm going to claim development value compensation. But if you acquire one of the alternative sites instead, then I will give you an undertaking or whatever. There was no actual agreement or undertaking signed in this case. Then I will give you an undertaking that I will only claim agricultural value compensation. And perhaps not surprisingly, the court said, well, that was clearly a matter that the Secretary of State and the Inspector should have properly investigated. So the relative land acquisition costs of, on the one hand, the CPO land, on the other hand, the alternative sites, was made a material matter by the offer of the landowner in the terms that I've just outlined. That is the only reason for referring to that authority.
While you're on it,
yes,
it's quite a strong statement by Lord Justice Tasker.
There is.
At the bottom of 418.
There is. That indeed has been cited, I think, in my learned friend Mr. Lockhart Mummery's case, and we don't.
We're looking at the final paragraph. I hope not the penultimate one, are we?
I think my lord was looking at the final paragraph. Yes, of course, my lord will be very familiar with this case, or at least will remember it, I'm sure. But yes, we don't take issue with any of that. Careful scrutiny, but by the Secretary of State in the confirmation process. That's our answer to that. Yes.
This case feels instinctively rather different. This is an alternative site, a few yards, 60 or 160 yards away, for the same development?
I'm not sure how far away
Well, it
was.
says so
Does
on
I'm sorry,
page,
I've forgotten.
it says page 402. It says there were two sites. One was 60, the other 160 yards from the railway line in the same area, each very convenient.
Yes, I don't think the proximity had, if I may respectfully say so, Myra, anything to do with the decision in the case. That wasn't a consideration in the decision of the court. But yes, my lord.
Well, I suppose it might have been if they'd been a long way away, so the alternative offers,
Well, I think it would have been
cheaper,
no, because
weren't
it would
so
have,
good.
well, it would have been a consideration on the merits of the case for the Secretary of State to examine, not for the court to examine. Yes, absolutely. If it was a long way away, then the costs may not have balanced themselves out, but it didn't go to the relevance of the consideration. But yes, my lord, I'm not suggesting the facts are on all fours or anything approaching all fours with the present case. As I say, I simply draw attention to it because it was the landowner's offer that made the relative costs of acquisition relevant to the Secretary of State's decision. And the court said he'd more or less ignored it, or at least hadn't investigated it properly. That's what the case is about in a nutshell. If I may move away from press CPO case, but if one looks at the other cases, mostly planning cases, but there is a CPO case, the Sovmox case, the cases which I'm about to mention do, in my submission, establish, well, that both in the planning and the CPO contexts, considerations of financial viability and the ability of one development or one component of a development to crop-subsidise another development or another component of a component of another development can be relevant. And the first authority is Brighton, to which I've already made reference. It's at tab 14 of volume 1 of the authorities. And I suspect a decision of Sir Douglas Frank, sitting as a deputy judge of the High Court. I've already outlined the facts. If I can just direct your Lordship's attention, I won't concern myself or involve your Lordships in the head note. I've explained, I hope, the essential facts, but it's quite a short judgment. On page 64 of the bundle, is at the top, the first half of the page, is where your Lordships will find that the inspector, this is the paragraph that starts, he then went on, so Douglas Frank saying the inspector went on to deal in some detail with the first issue, that was the amenity issue, and the inspector found that that was not of such, the playing fields were not of such visual and physical importance that development should be excluded. But then he went on to the second issue, which was about this subsidy from the housing development to the listed building, which was the main school building. And again, I obviously won't read it out, but it goes on to the rest of page 64 and up to the top of page 66, the relevant passage. If your Lordship see on page 66, after the word school in the second paragraph in square brackets, the rest of it is dealing with an issue that's not material for present purposes. But in a nutshell, the inspector in that case gave weight to the prospect, there was no legal obligation of any kind, but gave weight to the prospect that the trustees of the school would use the money generated by the housing development on part of the playing field to pay for the necessary repairs to and thereafter to maintain the listed building. And Sir Douglas Frank said that was a legitimate consideration for the inspector to have taken into account. The key paragraph, if I may respectfully suggest, is the one that starts near the bottom of page 65. And in the interest of time, that's all I'm going to say about that case. I hope that's acceptable.
This is the case, the correctness of which Lord Justice Staunton doubted.
Well, In Monaghan,
Yes.
I'd have to, I'm so sorry, I'd have to check that, I can do that later. That's, yeah. Well, that, my lord, is quite right. Lord Justice Thornton, letter D on page 534, on the tab 25, page 534, letter D. Writing may become close to infringing that principle, but with the greatest respect, it's my submission that the principle that Lord Justice Thornton himself set out there is itself to be doubted.
Lord Justice Carr seemed to think it was right at page 115 of the report.
Just before I get to Monaghan, can I though, perhaps, if I think it helps, otherwise I wouldn't do it, invite your Lordship's attention to tab 27. A decision, this is a planning case, was no trust in the Secretary of State. 27, the decision of Justice Wolverhampton then was, and indeed we see to the bottom of that another case in which my Lord Brown
Lost.
appeared. I wasn't going to say that. Appeared. The position in that case was that a six-storey office development was proposed as contrary to policy, and it was refused planning permission on that ground. The appellants argued that nothing else, no other development was economically viable, and that it was better to allow an office development contrary to policy than it was to leave the site area for any number of years. The inspector was unimpressed with that argument and dismissed the appeal, but Mr. Justice will quash the decision on the basis that the planning consequences of a project's viability or lack of viability had been relevant to the decision. And this is also a relatively short judgment. Again, I'm sure I'll be forgiven not in the circumstances, particularly not reading any of it out. But the nub of it is on pages 559 and 560. Can I just draw attention on page 559 in the left-hand column towards the top, the first full paragraph. Although the various authorities were citing conflicts in his view, this was at the time when JPL reported cases in the third person. So him was Lord Justice, confusingly. So in the judge's view, it was possible to reconcile satisfactorily the various statements which were made once it was appreciated the same focus, not necessarily for every more than twice, which in relation to planning matters, and that what could be significant was not the financial lack of financial viability of the particular project, but the consequence of that financial viability or lack of viability. And then he went on to say that the weight next at one paragraph was a matter for determining authority. Well, I won't read any more because I would obviously invite you all to read the case. There's a large chunk of quotation on page 559 on the right-hand column from the Solvermox case, the judgment of Mr. Justice Falls in the Solvermox case, which I'll come to in a moment. But my principal submission here is that Mr. Justice Wolf, in a planning context, agreed with what Mr. Justice Wolf had said in the Solvermox case, compulsory purchase case. But what he emphasised in particular, and we get this in Solvermox as well, was that it was for the Secretary of State to decide in any particular case whether development costs were relevant, and if they were, what weight was attached to them. That is the proposition to which I rely on this case.
This is relevant to the particular development
Yes, relevant
in this case.
to the particular proposal
Yes.
for decision making.
Yeah.
Yes. So if we move on to Solomon.
So this is rival proposals, halfway down 807, two-thirds of the way down, rival proposals, and looking to see what to take into account in deciding between them.
They weren't rival proposals exactly. What had happened was that there was only one proposal, but the appellant had looked at two other development proposals which were more in line with policy and had subjected them to financial appraisal and had said that those two alternative options
I see.
were not viable, and therefore nothing would ever happen with the site unless they got planning permission for a proposal that was viable. And that was their 6-storey office development. So there were rival proposals in the sense that the inspector was invited to look at the relative viability of different development possibilities, but there was only one scheme. The inspector's choice was grant planning permission or don't grant planning permission. He didn't have a choice to grant planning permission for something else.
I mean, Monaghan might fit into that analysis, mightn't it?
Yes.
The trustees of Covent Garden might have been able to pursue any development scheme without the funding.
Yes. My lord, that's right. I'm as I keep saying, I'm coming to Monaghan. Does that meet your lordship's question on that case?
It's a hypothetical example halfway down the quotation from Murphy, and then it's being applied at 560.
It is actually a quotation from Sovmot, in fact. But my lord,
Sorry, I beg your pardon.
I'm with you.
Yes, of course you are. Yes.
Sorry, is my lord looking at if the minister is faced with rival proposals?
Yes.
Yes.
That's
Yes.
exactly right. And
Yes.
it's a hypothetical example of the eccentric compared with the responsible developer who can show he's got a reliable scheme.
Yes.
And cost, it said, is something that's relevant, or
Yes.
the Secretary of State can regard as relevant.
Absolutely. Yes. There is, your lordship perhaps will observe a ... about 3/4 of the way down the page. If we go to Sovmot's, the passage that's cited in Sosmo, this decision of this Sovmot's went to the Court of Appeal, but the decision of the Court of Appeal wasn't concerned with the point that we're interested in this case. So we need to look at Mr. Justice Forbes's judgment. Tab 28, did I not say that? Sorry, tab 28. The passage from Mr. Justice Forbes's judgment that Mr. Justice Wolfe cited in Sosmo is at pages 575 to 576. So that's 575 just above letter C. Mr. Justice Ackner took the view that cost, etc. And it goes all the way across to just below letter C on page 576, where it ends with the sentence, my lords, on page 576, just below letter C. It's then a matter for the minister to decide whether or not in any particular instance cost is in fact a relevant consideration.
What he omits is if you use the bottom, 575F.
That's right.
One cannot shut one's eyes
Exactly.
to 576A at the semicolon line 4.
My lord is exactly right. Why I draw attention to it is because Sovmot's was a compulsory purchase case, and there were remarks in that passage that Mr. Justice Wolfe may have felt weren't relevant to the planning case he was dealing with, but this was a compulsory purchase case, Sovmot's, because he says just between G and H, having referred to the what was then the longest inquiry ever held in the planning field. It's been overtaken since. and cost-benefit analysis and all that sort of thing, I think the position is a fortiori with compulsory purchase orders under the Housing Act. The Secretary of State has a duty to consider costs in these cases, or at any rate in suitable cases may well have such a duty. So this is a CPO case, and he went on at the top of the next page. That, I think, is the extent to which the court can give a ruling. Costs may or may not be a relevant consideration, depending on the circumstances of the case. All that the court can do is to say that costs can be a relevant consideration and leave it to the minister to decide whether, in any circumstances, it is or not. Of course, it follows that the weight to be given to cost, if it is a relevant factor, is also a matter for the minister. So my submission perfectly clear from both of these decisions that, that what the court was saying was that relevance and weight, materiality and weight, were both matters for the confirming authority.
So you say there couldn't be a principle of law, that there must be a reasonable relationship between the development or the acquisition and the cross-subsidy?
Well, there could be, but you don't get it from these authorities. You get the reverse, is what is my submission. And well, we'll see in a moment, because I now am going to go to Monaghan, that Lord Justice Thornton thought that in the circumstances of that case, a planning case, that a line ought to be drawn, but the other two judges didn't think so. I mean, if we can go on to Monaghan, as I keep promising or threatening to do, tab 25. My lords have the facts already, and I don't need to go over those again, other than, if I may, just give a reference in relation to the matter that came up yesterday to page 516. The paragraph that begins at letter C is dealing with the Opera House improvements, 516 letter C. 516F is dealing with something else, namely the separate substantial, it doesn't say separate, that's my word, but the separate substantial commercial element, which is quite a lot of office floor space, and net additional 14,500 square metres of offices. And so, in that case, the only connection between the offices and the I know there are other facts that were brought into play, but the only actual connection between the offices, the commercial content of the scheme on the one hand, and on the other hand, the Royal Opera House refurbishment works, was the cross-subsidy. Again, in the interest of time, if I may, I'm going to just draw your lordship's attention.
You say that, I mean, I haven't quite got a picture of the physical, but it says the project incorporates, bearing in mind what one doesn't know of the location, it's not clear to me, actually, that the offices are physically separate. I think you said that you go across the high-level bridge to more offices belonging to, or dressing rooms, rehearsal, the ministry offices of the ROH, and then the same building continues further up to Longacre and has the offices. Is that the
we're helped a little bit by page 509 on the facts, although one also needs an A to Z, really, depending on the extent of one's knowledge, because we see there, beginning at letter F, what the extent of the site was. Royal Opera House, Floral Hall, obviously next door, part of now the Opera House, 2 Bow Street, buildings in Russell Street, Mart Street, Floral Street, Longacre, and land fronting James Street. I mean, I'm going to submit respectfully that that the physical proximity was just a factor on the factual matrix in this case. There's no legal test set down that there has to be physical proximity. I'm not suggesting that these offices were a long way away, but they were separate. They're commercial offices. They've got a separate entrance. There's no... The directors of the company, what by the office, don't have a passageway into the royal box or anything. I don't think. So separate in the sense of, I mean, I'm afraid I just don't know whether the buildings are actually physically separated by airspace or other buildings. I'm afraid I don't know that. But they were all close to each other. There's absolutely no doubt about that. But if I may just invite attention, first of all, to the judgment of Lord Justice Carr, and as I've been trying to do, just indicate to your lordships the most relevant passages. As far as his judgment is concerned, page 522, letter F, through to 523, between letters F and G. I'm not suggesting that what follows after letter G in 523 is relevant. It's the review of some of the authorities that his lordship undertook at that point. He then applied to 5 letter F when Mr. Bradford and full insurance. And then, at page 526, well, letter D, but particularly letter E, having looked at all of those cases, his lordship said, but Mr. Palmer, that we then want to appeal for the claimant in that case, challenge this analysis, whilst agreeing that no ulterior motive was involved, he didn't accept what he called the but-for argument. And this perhaps is quite important. The but-for was permitted the undesired office accommodation, the desired development of the Opera House could or would not take place, and he pointed out that there were powers under the Local Government Act that were relevant. But then his lordship said, I cannot agree with this analysis. There are few, if any, situations in which the but-for argument could not be countered by pointing to alternatives, but alternatives of a nature which the relevant authority may reasonably consider to be uneconomic and therefore impracticable. Such situations do not invalidate the but-for argument. If sufficient money is available, almost anything can be done, but that's no test for the balancing exercise involved in the determination of most planning applications. The Council was entitled to proceed on the basis that but for the permission to the RH to include the office accommodation, this wouldn't proceed at all. So that's obviously quite an important part of the reasoning. And then at D and F on page 527, Lord Justice Carr considered the decisions in well, first of all, Niarchos, but then Brighton, to which I've referred, and Sosmo Trust, to which I've also referred. And then over the page 528, that he ends up by saying at letter F on 528, for the reasons already said, I'm in full agreement with that approach. That is Mr. Justice Wolfe's approach in Sosmo, and in my view it determines the first issue of this appeal. He then came to hypothetical extreme illustrations, page 529, letter C, and he volunteered the view that the combination of an office block in Victoria to generate desirable development in Covent Garden would be unlikely to be properly entertained as a single planning application or as an application for one composite development. I therefore say no more about it, save that, and this I respectfully suggest is very important. All such cases would, in my view, involve considerations of fact and degree rather than of principle.
Sorry, just which page
So
again?
sorry, I'm to apologise. 529,
Yes,
C to D.
see you. Thank you very much, yes.
So think of any extreme hypothetical illustration you wish. Lord Justice Carr's answer is, well, that's a matter of fact and degree, that is, if I may interpolate for the decision maker, rather than one of principle. And with respect, I would respectfully suggest that the question, could it or could it not have been in the same planning application, really cannot be of very much significance. I mean, the Opera House could perfectly properly have made separate applications for the commercial offices and for the Opera House. Very understandably, they chose not to do so, and the planning authority didn't have any difficulty with that. But it's difficult to see, if they had done that, why the cross-subsidy would not still have been a material consideration.
I'm a bit puzzled about the fact and degree. I mean, does it depend upon how far Victoria is from Covent Garden? Would it be unacceptable acceptable if it was in Mayfair and unacceptable if it was in Victoria, or acceptable in Victoria and unacceptable if it was in Clapham or in Bristol?
Matter of fact and degree.
Well, what's that mean?
Well, it means decision making.
Surely, I mean, I would have thought it might be linked to the previous sentence where he seems to suggest that important in this case was the fact that it was a single planning application or a composite development. Once you get something outside the scope of the immediate Covent Garden Opera House development, and you can't say that.
With respect, he's not saying that. He's saying that that in those circumstances there probably couldn't have been a single planning application, although I'd respectfully suggest there might have been. As I said yesterday, Tesco could have made a single planning application perhaps for the RSS and the RHS, but they decided not to do so, and I can't see how that can affect the principle of whether the cross-subsidy in this case is or is not relevant.
But it couldn't, if they applied in one application, it would have been palpably, wouldn't it, for two separate developments. It wouldn't have been one development or a composite development by any stretch of the imagination.
But you don't have to apply for one composite development in one planning application.
No, but I'm just trying to see what the test adopted by the Court of Appeal here was. It doesn't seem to me very easy to know what facts you're looking at and what degree, if it's just a question of fact and degree.
Well, I think, with respect, all one can say about what Lord Justice Carr says here, and Lord Justice Nichols said the same thing, I think we'll find, is that hypothetical extreme illustrations aren't particularly helpful. Look at the facts of the case in hand. If there hadn't been a single composite application, well, it would still be a matter of fact and degree, not principle, for the decision maker. I mean, if you say, in our case, of course, in the context of Section 226, if I may say so, the geographical limit is set by the authority's boundary, because the well-being benefits have got to arise within the area. But in a planning case, I mean...
well, is that right? Because if you lose on point A, we're now arguing the second point, and the area drops out of the picture.
Yes. Yes, my lord is right. That must be right, actually.
I mean, really, you say
yes,
this extreme example, well, it may be extreme, but nevertheless, in principle, there's no reason why you shouldn't be allowed to have an undesirable office block in Victoria if that's going to enable you to restore the Royal Opera House. That's your case.
I do say that.
And you say that with a planning permission as well as with a CPO, although you say CPO, you're in better case still. But you say actually, as a matter of principle. So really, I mean, this business about you can't buy a planning permission, you say basically you can. And you may be right, but I mean, is that right?
No, I don't say the last thing.
Well, why
that you can buy a planning, because it all depends on what's meant by buying. I mean, Lord Hoffman in Tesco, as your lordships will see, didn't think that was a particularly helpful question to ask.
I know.
Your lordships may take a different view, obviously, but I mean, it's as soon as anybody says you're buying or selling, buying this planning permission, one immediately says, well, what does that mean?
Yeah.
Well, obviously, it's meant to be pejorative to say you're not allowed to buy a planning permission. Of course, you're not allowed to buy a planning. You're not allowed to pay the chief executive £500,000.
Right.
Put it in his offshore account in order to get the planning permission. That's obviously the wrong side of whatever line you care to think of.
I think you're mixing corruption with planning.
I don't want to do that.
But you say basically planning gain, whatever, wherever it's to happen, planning gain. Yes, here it happens to be planning gain. I mean, it might have been social gain or some other gain. But anyhow, gain of this sort and desirable gain is something that you can have regard to in any of these planning cases.
Yes, that's right. Can I then...
You're not leaving this case, are you? Because I just wondered whether we could look quickly at Lord Justice Nichols at page 533, because I just wondered whether you say he's making the same point there, do you? He discerns no legal principle between the things he refers to.
He informed this himself in the middle of 532 then he deals with Mr. Coleman's slippery slope argument, and Lord Justice Nichols not persuaded by the reductio my submission that neither, well, that both in a different way, both Lord Justice Carr and Lord Justice Nichols agree with Mr. Ford's that relevance and weight in that.
Well, it's again interesting that he uses the phrase one composite development project and says that as such it was open to the planning authority to balance the pros and cons. So, I mean, if one's looking for facts or degrees, that's the particular conclusion which seems to have been quite important for both those judges.
But what you say is it's not authority for the converse, or not authority against the converse.
I do say exactly that. In other words, physical proximity, part of one composite development project, were not stated as legal tests in any way. They were part of the factual matrix that enabled the court or led the court to decide the way it agreed. Now, turning to Lord Justice Staunton, we looked at several times already. Lord Justice Staunton, the bottom 533, said we've got to draw a line somewhere. The other judges didn't think it was necessary. But again, if I may, attempt to obviously press on, he drew it, well, there were 2 points really. One is that in the middle of 534 at letter D, he gave the swimming pool example, of course, and compared it between Czech and referred to Brighton. But he then at letter E, perhaps potentially important, referred to the speech by Captain Newbury. Conditions imposed on a planning commission must fairly and reasonably relate to the development permitted if they're to be valid. So must considerations if they are to be material. That does not survive Tesco. The lordships will see that is not the test for material planning. Secondly, nor did Lord Justice Staunton suggest that physical proximity in one composite development were legal tests. They were just part of the factual matrix of that case. So, and I've just got, I'm sorry, it's 3 o'clock, but there's Plymouth and Tesco to deal with, and I hope that I can deal with those very quickly and just make some final key submissions. Plymouth is at tab 24. Now, your lordship will remember, your lordship will remember from yesterday that this was the case in which Tesco and Sainsbury, amongst others, I think, were applied for planning permission for supermarket development, and they were invited by the council to provide a list of the benefits that, in short, that their development was providing. We've got a list of the goodies on page 498. In the appendix to the report, and these are the core listings as part of the judgment, effectively, as I understand it. Anyway, we've got, as I say, the goodies listed. We concentrate on off-site benefits. Tesco included improvements to a road on a scale not required to accommodate the traffic in the development, and a park and ride scheme on another site. For example, Sainsbury goes along with this. In their case, their off-site benefits include £250,000 for highway improvements not required to accommodate the development. It's important to remember that this all sounds to be okay. 9 and 10, contribution of £800,000 carbon life scheme unrelated to the development, and a contribution of £1 million to the development of industrial purposes of another site owned by another. And I've got touch on that point in particular yesterday. Section 86 agreements were entered into, and they both got planning permissions, but the co-op weren't very happy. They wanted the planning permission too. Again, if I may just try to draw attention to the key passages in the judgments, Lord Justice Russell, first of all, 487 to 488.
Is section 106 anywhere set out? Do we have?
Yes. As it was then,
Yes.
it has been amended. Well, we've got it. Section 7, subsection 2. We've got section 106 as it is now in our volume 1 of authority. Now 11. And that's as it now is. But there have been amendments since but maybe more material ones. The Lordship has it there. One sees what the issue in the case was, and we'll see in a moment that in Tesco, the ratio of this case was very tightly defined by two of the judges in Tesco. The issue in the case, bottom of 487, was that only community, this is Ms. Gilbart's submission, only community benefits that were necessary to overcome the remedy or alleviate planning objections to be taken into account. That was the issue in the case. And then there's a reference to Newbury, and I think that's meant to be Lord Fraser of Tully. Page 488. It's speech in Newbury. And that, someone, I'm not sure who's written numbers in the margin, but those are the three tests for the validity of a planning condition, and Lord Justice Russell said at the top of the page the same must be true of the section 106 obligation. And then further down 488, if I may, about 10 lines from the bottom, I simply ask myself whether each and every one of the obligations capable of being regarded as having a planning purpose, and whether each and every one of them related to the community development. He then dealt with the off-site benefits and said, this is over page 489, that they all hit the boxes. Lord Justice Hoffman followed a similar approach. My Lord, if I would go to page 493, about two-thirds of the way down, having sideline passage, having referred to section 7, subsection 2, Lord Justice Hoffman, who then also was in this context of material consideration, see Newbury. Planning conditions 3 says planning purpose, fair and reasonable, relate not whether to be unreasonable. 1 and 2 test materiality. Considerations are material under section 72 if they are planning considerations of fair and reasonably relate to the development. And he then went on to look at some cases including Bradford and Monaghan at the bottom of 494, and that's worth picking up the remark he made 5, 6 lines at the bottom, the issue 494. In Monaghan, whether a sufficient nexus existed, this court found such a nexus in financial dependency and physical proximity as much as to suggest that the desirability of the house improvements would have ceased to qualify for material considerations within their planning application, objection to the offer. The significance of the decision-making process would have diminished, but that's not the same thing as how strict the policy of materiality. With the greatest possible respect, which I think perhaps just more accurately, rather than the desirability of the house improvements, it's the need to cross-subsidise and the thing that was found to be material consideration. Okay. But having done that, Hoffman also found that the benefit met the relevant test, in that case, page 496 over to 497. Now, that case, as long as it's got subsidy itself.
Where does the test of relate to the development come from? Is that part of section 106 as it was?
No.
It's not.
No,
Newbury.
It's the second of the 3 tests of conditions in Newbury that the planning condition, and therefore this court held, as I understand it, therefore the test of the validity of the planning obligation and the test of the materiality of a consideration as a planning consideration were the Newbury tests, namely planning.
Does it go back to Pick's granite? Is it? I suppose. I mean, that's. I'm just looking at page 488 where we see it all set out.
So that's where it comes from. Picked granite, not from the statute at all.
No.
Picked granite and then the Newbury conditions.
But I mean, is your point that, okay, it's one thing to say it must fairly and reasonably relate to, if you're actually going to impose a condition on a planning permission, but that actually is not the same, a necessary ingredient of a consideration when you're then looking to see whether you can, so to speak, get your application preferred.
I am saying that, but I'm also saying that this didn't quite survive Tesco, this approach. As we'll see in a moment, Lord Hoffman, as he had by then obviously become, stepped back, it's fair to say, from what he said in Plymouth. But that's what Plymouth says. But
And it underlies Monaghan as well, doesn't it, the Newbury test?
no,
Well, 523, 524 of the bundle.
yes, certainly it was referred to, but it was a case about the validity of planning conditions, Newbury.
Yes.
It wasn't about material considerations in the context of Section 70, subsection 2. And it is actually that, if I very respectfully may say so, is what their lordships appreciated, for want of a better word, in the Tesco decision, that you couldn't and shouldn't just apply the Newbury test for conditions to material planning, let alone, obviously, I would say, to a Section 226 CPO. But that is how Plymouth came out. But it wasn't a cross-subsidy case. It wasn't a CPO case. It wasn't even a competing developments case, I suppose, in the end, because 2 planning permissions were granted. And I don't think anyone is indeed suggesting that the Newbury test should be applied in relation to 226 CPOs. But if I will go on to Tesco, because that's the end of this particular story. That was a case in which Tesco and Sainsbury, of course, were in competition for a single planning permission in Witney, tab 30. And as your lordships heard yesterday, there was this link with the West End link that was a road that the council had as a policy in its policies for some time, I think, but didn't have any money to build it. And Tesco said, well, we'll pay for it. Now, what happened at the inquiry, and it's important perhaps to appreciate this, is that if my lords in tab 30 go to page 669, at letter G, this is the speech of Lord Keith, where he is citing passages from the inspector's report. And what we see there in paragraph 7.4, just below letter G on page 669, is that the inspector had found there is some relationship between the funding of the West End link, that's the link road, and a proposed store, in that a store would slightly worsen traffic conditions in the town over and above the existing planning permission. So there was already a planning permission for the Tesco site. The relationship is, however, tenuous. Any superstore site would be a considerable distance from the West End link and Bridge Street, and the development proposed would not generate a great deal more traffic than the other permitted use of the site. The Secretary of State agreed, my lord. Page 674, letter G. This is paragraph 7 of the Secretary of State's decision letter. 7 at letter F, turning to the West End link, I can pick it up at G. He agrees with the inspector, that's the Secretary of State, that this slight worsening of traffic conditions produces some relationship between the funding of West End link and a proposed store, but shares her view that the relationship is tenuous, given the distance and the little extra traffic. And then he went on to find that it wasn't a necessary planning obligation. Now, going on, to page 676, at letter A, well, actually one has to pick it up at the bottom of 675, because there is cited a passage from the speech of Viscount Dillon, 675, letter H, in the Newbury case, where Viscount Dillon said it follows the conditions imposed must be, and these are 3 tests, planning purpose, fairly and reasonably relate to the development, and not Wednesbury unreasonable. Then he went on, and this is important, the same test, so it's claimed, falls to be applied to a planning obligation for the purpose of deciding whether it amounts to material consideration in connection with an application of a planning permission. The parallel, however, cannot be exact. No doubt if the condition is completely unrelated to the development, it won't be lawful, but this case isn't concerned with the lawfulness of the obligation, and there may be planning obligations which have no connection with any particular proposed development. We touched on that point yesterday, I think. In Good and Epping, that was held, so I do not think that reference to the Newbury case is particularly helpful for the purpose of deciding whether a particular planning obligation is a consideration which is material to the determination of a planning application with which the obligation is associated. He then went on to deal with Plymouth. Between letters E and F, your Lordships will see that Lord Keith said the Court of Appeal held that it was sufficient on the basis of Newbury that the obligations offered concerned planning matters and fairly and reasonably related to the proposed development. The only member of the court who referred to the then circular was Lord Justice Hoffman, and then there is a citation from Lord Justice Hoffman's judgment in Plymouth dealing with the principle of necessity. And so it's at the bottom of the page where we find what Lord Keith said the ratio of Plymouth was. 4 lines up from the bottom of the page. The effect of the decision, therefore, is simply that the local planning authority isn't acting unlawfully if it fails to apply a necessity test in considering whether a planning obligation should be required or accepted. It does not decide the converse, namely that the local planning authority would be acting unlawfully if it did, as a matter of policy, apply a necessity test. And he then said, an offered planning obligation which has nothing to do with, that's the test, nothing to do with the proposed development, apart from the fact that it is offered by the developer, will plainly not be a material consideration and could be regarded only as an attempt to buy planning permission. If it has some connection which isn't de minimis, then regard must be had to it, but the extent, if any, to which it should affect the decision is a matter entirely within the discretion of the decision maker. And then I probably don't need to read out any more. And then at letter F, he comes to deal with the application of that principle to the facts of that particular case, and found that far from what has been argued on that occasion on behalf of Tesco, namely that the Secretary of State had wrongly left out of account the offer to fund the ring road. The Secretary of State had taken it into account and had fully considered it. The problem for Tesco was that the Secretary of State had decided not to give it any weight. And the court said that was perfectly okay. So that's Lord Keith. Then Lord Hoffman, if I may take your Lordships on to page 682 in the speech of Lord Hoffman. This is a passage in which he referred to the circular, as he'd done in Plymouth. And at letter A, he said that the circular, very first line, says that any benefit sought in return for a grant of permission must be related to the development and necessary to the grant of permission. 2 limbs, relationship to development, necessity for the grant of permission. The need for relationship flows from the requirements of section 70, subsection 2, which he then cites, and then says, in that immediate context, a benefit unrelated to the development would not be a material consideration. A refusal based on the developer's unwillingness to provide such benefit would therefore be unlawful. Then there's more material about the circular, which I don't need to trouble your Lordships with. He then, on page 684, at letter F, starts to deal, or refers to a situation, my Lords will see in the 3rd line of that paragraph, beginning between F and G on page 684, of cases in which developers are in competition for a planning permission. And under H, I do not think anyone would doubt that in such a case competition it would be legitimate to take into account that one developer is willing, for example, to employ the finest architect, etc., where the other developer put forward something much worse. But, he said, he didn't say but, the last sentence is, the problem arises when a developer tries to win the competition by offering more off-site benefits. He then went on to deal with the Plymouth case, and he explained the ratio of the decision at letter F on page 685. What he said was the Court of Appeal was content to deal with the matter on the basis that the Council had indeed taken into account promises of benefits which, though relating to the proposed development, were not necessary for the grant of permission within the terms of the circular. Dismissed the appeal on the ground that the test of necessity, whether as explained in the circular or in any other form, wasn't a legal requirement. So that, he said, was what he and his fellow judges had decided in Plymouth, entirely obviously consistent with what Lord Keith had said about the ratio of Plymouth in his speech. And then we find that in section 11, under the heading of planning obligations in the Newbury test, he says, although I was party to the Plymouth decision and accepted the transposition of the 3 Newbury tests to the validity of a planning permission granted on the basis of a planning obligation, I am bound to agree with my noble and learned friend Lord Keith that the parallel is by no means exact. And this is where, in my very respectful submission, he steps back somewhat from a simple application of the Newbury tests to section 70, subsection 2. And at 686, first of all, letter C, he identifies 3 particular matters that need to be borne in mind. The first is that a planning obligation isn't the same as a planning condition. The tests for planning obligations are different. And at letter D, he says, the only test for the validity of planning obligation outside the express terms of section 106 must be for a planning purpose, not Wednesbury unreasonable. So that's the first and the third of the Newbury test, but not the second one, fairly and reasonably relate to the permitted development. It's normal to offer an obligation in connection with a development, but it doesn't happen in every case. Secondly, I'd obviously like Lordship's obviously to read the whole passage, but I won't read it all out myself. At letter F, secondly, this is the second point to be borne clearly in mind. It doesn't follow that because a condition imposing a certain obligation would be regarded as Wednesbury unreasonable, the same would be true of a refusal of planning permission on the ground that the developer was unwilling to undertake a similar obligation under section 106. And then thirdly, at letter H, whilst Newbury is a convenient judicial paraphrase of the effect of section 70, subsection 2, it cannot be substituted for the words of the statute. Really, in the end, you've just got to see whether the obligation was a material consideration and whether regard was had to it.
Sorry, I'm rather losing...
I'm so sorry.
No, it's not your fault. No.
I've gone too far.
It's my fault, but, I mean, what he says is there's a difference between the validity of a condition and, on the one hand, and a planning obligation, which is a 106 obligation on the other. I mean, presumably a planning condition is something that's imposed upon you by the planning authority. The other is a planning obligation that you voluntarily undertake.
Yes.
Is that what he's saying? But that is a distinction. Is that right?
It certainly is a distinction. I think he's also drawing a distinction as well, because section 70 is in different terms to section 106, and doesn't, amongst other things, even have to be. You can enter into a planning obligation quite aside from any grant of planning permission.
Fine.
Yeah.
Then a planning obligation. I mean, when's a planning obligation going? Which, by definition, is going to give some benefit to the authority, isn't it? It's a planning obligation on the developer.
Normally, well, it's difficult to think of.
When's it going to be Wednesbury unreasonable? I'm a bit lost. No, really. I mean, I'm sorry. I mean, I can see secondly at F, because of a condition imposing an obligation, such as CLA, that might be regarded as Wednesbury unreasonable. But I mean, I can't see when it would be for a 106. I just don't understand it.
Well, my lord, I'm not sure I can help very much. I mean, what one has to remember, which is quite easy to forget actually when one's reading this particular passage, is that actually what Tesco is about, like Plymouth, it wasn't about the validity of a planning obligation. It was about the materiality of a planning obligation that had been entered into to a planning decision under subsection 2 of section 70. That's what this case was about. But in this passage, Lord Hoffman is dealing with what he said in Plymouth. And if one looks at the context for those 3 points, it's just below letter B on page 686. The use of the Newbery test in relation to planning obligations can cause confusion unless certain points are borne clearly in mind. And with the greatest respect to Lord Hoffman, I have to say I read this passage as saying the second Newbery test isn't relevant to planning obligations, actually.
Sorry, but then at H, when he gets to the third, he then says the principal questions must always be whether the planning obligation, note, not the condition, the planning obligation, whether that was, and then he uses the language of 70 subsection
That's right.
2, material consideration.
Well, certainly in the third point, it seems to me that he is dealing not with whether actually the Newbery test for planning conditions apply to planning obligations, but he's moved on to the question in the case, which was, when is a planning obligation material to a planning decision under section 70 subsection 2, which is a different question. I mean, that's the only way I can read that paragraph at letter H. But all becomes, if I may respectfully say, a little bit clearer if we, as it were, get to the end of Lord Hoffman's speech. Section 15, we can pass over, I think, material 13 and 40. Section 15 starts at 689, and it's this that I referred to a while back, buying and selling planning permissions. 689, obviously letter B, and the critical passage perhaps, well, it is between B and G, and he says that Plymouth had led, this is letter C now, to a concern among academic writers and one of the judges in the Court of Appeal in the present case. The court was condoning the sale of planning permissions to the highest bidder. My lord, to describe a planning decision as a bargain and sale is a vivid metaphor, but I venture to suggest that such a metaphor, and I could myself have used the more emotive term auction rather than competition to describe the process of decision-making in the Plymouth case, is an uncertain guide to the legality of a grant or refusal of planning permission. It is that sentence that I had in mind when I made the submission I did a while back. It's easy enough to apply in a clear case in which planning authorities demand or take account of benefits which are quite unconnected with, compare my Lord's Lord Keith, nothing to do with, quite unconnected with the proposed development, but in such cases it merely adds colour to the statutory duty to have regard to material consideration. In cases in which there's a sufficient connection, the application of metaphor as well as the legality of planning decision may be highly debatable. Already explained how in case of competition such as Plymouth, it may be perfectly rational to choose a proposal which offers the greatest public benefit in terms of both the development itself and related external benefits. And then, if we go over the page 690, finally, it's quite an interesting passage actually, because on page 690, letter B, just below letter B, so I think that Tesco's argument is a perfectly respectable one. I haven't really touted it starts letter A from the previous case. They said, well, you know, we're not buying a planning permission, we don't want to buy a planning permission. Okay, we're only going to add a little to the congestion, but you know, this bridge is never going to get built if we don't pay for it, so why can't we pay for it? Mr. Kostowski's counsel for Tesco in that case. I said that argument that his lordship thought perfectly respectful, choice of policy which emphasises the presumption in favour of fairness between developers, such as guided the Secretary of State in this case, and a policy attempting to obtain a maximum legitimate public benefit, which was pursued by the local planning authority in the Plymouth case, lies within the area of discretion of departments entrusted to planning authorities, not a choice which should be imposed on them by the court. I therefore reject the Plymouth document on his submission. Sainsbury in that case, if Tesco's offer was not a material consideration. I think it's noted that the Secretary of State has taken Secretary of the Plymouth City Council into the Plymouth case and given the planning permission to Tesco on the grounds that its proposal offered the greatest public benefit. The Secretary didn't do so instead he applied the policy of slope and decided to attribute little or no weight to the offer. So his lordship was saying that well aware that the state inspector and Secretary of State had found the connection to be tenuous. They could have gone ahead to grant a commission test on that basis if the Secretary of State wanted to. But he chose another course which was equally within the scope of his discretion in the particular case. Now, none of that obviously is directly applicable to factors that may or may not be taken into account. Authority and Secretary of State in deciding whether or not to make confirm a section 226 CPO, may be suggesting it is, but I certainly would respect that there's no conceivable warrant for applying, for example, a fairly and reasonably relate test, the Newbury test for planning conditions, in the context of section 226 CPOs, and indeed Tesco says it doesn't apply to planning obligations either. But, on the other hand, my lords, there is authority, both as we've seen in the CPO context, Solvmot's a CPO case, and in the planning context, Monaghan, to this effect in my submission, to put it as shortly as I can, considerations of cost and financial viability may be relevant, and that relevance and weight are matters for the decision maker. And let me go directly now, in the light of those authorities, to the question that's obviously most troubling the court. Are the Royal Hospital site well-being benefits a likely consequence of the RSS development? Do they flow from it? And in our submission, obviously, yes, they are. First of all, in our submission, there is nothing wrong in principle with taking account of well-being benefits which will flow from the carrying out of the development of another site in the authorities area, which is facilitated, enabled, encouraged, brought about, whether wholly or partly, as a consequence of the carrying out of the development on the order land. There is nothing wrong in principle with an authority taking account of the fact that by this development taking place here on the order land, it will act as a catalyst for other developments to take place in the relevant authorities area.
Are you not misusing the word catalyst?
Am I? Maybe I am.
Well, what do you mean when you say a catalyst?
Well, what I had in mind, I suppose, was Lord Justice Sullivan's example in his examples in his judgment in the Court of Appeal. Perhaps catalyst, or using the word catalyst, introduces an unnecessary complication to the point that I'm trying to make. What I'm trying to submit, first of all, is that there's nothing wrong in principle if the development of the order land in any particular circumstance is likely to lead to, whether it's by cross-subsidy or by any other means, and you can use the word facilitate, enable, encourage, provide for, bring about development of another site in the local authorities area. My second submission is that what section, just to focus back on section 2261A, and then I'll make some separate and very brief submissions about the alternative argument. But secondly, what section 2261A is concerned with are, in my submission, the consequences of the development, redevelopment, or improvement of the order land. That's what the words in my submission mean. And those consequences include the consequences of intended developments or redevelopments that may not have planning permission at the time that the order is made. Before planning permission quite often it has been, sometimes it hasn't. They include those consequences of improvements that may or may not be self-explanatory. Thirdly, it is, of course, the economic, social, and or environmental consequences of the development. Section 2261A requires the authority and then a scheme of development, redevelopment or improvement is likely to have a range of consequences, maybe many such consequences, both adverse and beneficial. An adverse consequence, for example, would be the loss of space. Beneficial consequence would be the creation of jobs. Now, we submit, fourthly, that one of the beneficial well-being consequences of Tesco's RSS development will be the RHS development and the well-being benefits that will flow from that. And we submit, obviously, as firmly as we can, that that is a consequence, and it is a legitimate consequence of the RSS development, essentially because, one, the RSS development will cross-subsidise the RHS development, and two, but for that cross-subsidy, the RHS development is unlikely to take place. And were the court to hold that that is an illegitimate consideration, would not only be, we submit, contrary to the Monaghan line of authority, but also, and I respectfully suggest this is quite important, would be to ignore economic reality and to achieve a result that would be directly contrary to the aims and objectives that have underlain or that underlay the introduction of the well-being power. The benefits of the RHS development are in the Cabinet report, I think at paragraph 612 onwards or thereabouts. I won't take your lordships to those again. So those, in a nutshell, I hope, can be described as a nutshell, are our submissions really on the section 226(1)A issue. On the second issue, which is, of course, would the council or the Secretary of State thereafter be precluded by some public law principle from taking into account the RHS benefits anyway? Lord Hoffman, as we've seen in Tesco, was quite clear that the phrase that he used, benefits which are quite unconnected with the proposed development in that planning context, he said merely adds colour, that phrase, to the statutory duty under section 72 to have regard only to material considerations. There is, of course, no longer any such duty under section 226. There was.
So 226 goes out of the picture once we get into this stage of the argument.
Well, it's still, my lord, with respect, does it go entirely out of the picture? We're still examining the question of whether this is a relevant consideration. We're assuming it doesn't come in under one big A, but we still have to examine the question, is it a matter that's relevant to the exercise of that power, not the section 70 subsection 2 power? So we're still in a section 226 world, if your lordship, if I may use that expression. So if I'm taking 226 as it is, but ignoring subsection 1 big A, if I may, if I were to attempt, and I'm about to attempt to apply the quite unconnected with test, or nothing to do with test from Tesco, to the RHS well-being benefits, or let's get away from the word well-being, to the RHS benefits, well-being or otherwise, we submit that there is a clear connection to, or nexus with, the RSS development, because firstly, both sites lie within the area of Wolverhampton City Council. Actually, they're quite close to each other if you look at tab 12.
They're half a mile apart, we've been told.
Good. Well, I'm suggesting that's quite close.
I thought all the argument was proceeding on the basis that there isn't a physical nexus between these two developments.
Well, if the court is going to have regard to the question of physical proximity, in Wolverhampton City, they are quite close. I mean, some of the other sites, your lordships have seen from that plan at tab 12, that the policies divide the city centre up into areas. But even some of the sites within each of those policy groupings, there are 3 CC9 sites, I think, on one side of the city centre and another one on the other side of the city centre. I mean, I'm not suggesting that that's a critical consideration in any way. I'm simply pointing out that, if physical proximity has any relevance, well, they're both within the authority's area. And if you want to go further than that, you might think they were quite close. But I'm not making any more of the point than that. I'm certainly not suggesting our making good my submissions depends on your lordship's accepting that. It's a factual observation.
Well, what parameters are you suggesting now apply where the local authority is choosing between 2 alternative developments involving grant of planning permission, either of which ticks all the right boxes, or each of which ticks all the right boxes? I mean, what if one developer owned by an individual philanthropist who says, if I can do this development, I'm going to fund inoculation against swine flu for every single person living in the local authority area?
Well, it would be
would that be a valid?
It may not be a material planning consideration.
Well, that's what I'm trying to find out.
Well, it may not be a material planning
consideration. What parameters do apply once?
Well, in the context of what I'm trying to deal with at the moment, my lord, is section 226, and whether it's material. I'm trying to apply the Tesco principles in the context to the facts of this case, which is a section 226 case. Obviously, if I'm going to deal with the question, which I'm obviously happy to do, what if this was a planning case? Then if your lordship gives me the example of swine flu inoculation, I strongly suspect that would probably fail the first Newbury test, namely relevance to planning. That's relatively easy.
We're into 226, but we've got 2 proposed developments, each of which ticks all the boxes you need to have ticked for the exercise of compulsory purchase. The question is, what criteria can validly be considered when choosing between the 2? And I'm putting to you, if one developer is offering to bestow advantages on those who live in the local authority area, which have got nothing to do with development at all, maybe to do with health or education, can you or can you not? Can the local authority say, well, we'll be much better off if we give the development
if they've got nothing to do with planning,
in
the planning context, then they can't be material. And inoculating people against swine flu seems to me to be a social benefit. I'm sorry to come back to section 226, but it would come in under 1A. But in the planning context, I can't see that would be. I mean, it's not relevant to planning.
No, but why do you have to? Once you've got the 2 alternatives, have you got to restrict consideration of benefit to planning benefit, or can you go wider?
In the planning context, certainly you don't have to in the CPO context. In the planning context, if one is to apply, maybe I'm missing the point, I'm sorry, but in the planning context, if one follows the decision in Tesco, for a consideration to be material, it has to be relevant to planning, and not Wednesbury, and not a consideration that it would be unreasonable, i.e. perverse, to take into account.
Yes.
That's
but here we're looking at 226, and you've got to get over a number of hurdles on 226. The compulsory purchase must be for the purpose of development. The development has got to tick the right boxes so far as the development imposing benefit is concerned, whatever that means.
Yes.
But if you have 2 alternatives, proposals with different developers, with nothing to choose between them so far as these matters are concerned, can the local authority or can, say to itself, well, developer A has offered to confer a very considerable social benefit on those who live in the local authority area. Developer B has not. Ergo, we're going to prefer developer A.
Yes.
You can.
Why not?
Well, this would...
The Secretary of State will weigh that up. But yes, undoubtedly in a Section 226 context. Can I
just understand?
I'm sorry.
The argument on Section 226(1) little a, which we're focusing on at the moment, is that, have I understood it correctly, if you have power and the condition of that is that you think that the acquisition will facilitate the carrying out of development, etc., on or in relation to the land, that is simply a threshold, and thereafter you can take into account any consideration you like, or which you think is appropriate, whether it's related to the land or to planning or anything.
Well, it's at least, yes. I mean, it's got to be related in a broad sense to the local authority's functions. I mean, I gave the example of a, well, I won't go back to my example.
Yeah, so that 2261 little a isn't an indication of the relevant statutory considerations on your argument. It's simply a starting point. Once you get over that threshold, anything comes in that's relevant to the local authority's functions.
Yes, yes. I mean, it isn't, yes, section 226 1A is, sorry, I've already pointed out, it's just simply not couched in the same language at all as section 70 subsection 2. All those cases
it
about what a material consideration.
It is in a sense, because if section 226 1A indicates the factors which a local authority should take into account, and of course it has to take into account some additional factors under 1 capital A.
Yes.
But if 1 little a is the factors which are relevant and sets the parameters of those factors, then they must be factors which relate to the facilitation of the carrying out of the development on or in relation to the land. So you do get in relation to there, but you say, as I understand it, that it doesn't set any parameters, it just simply sets a threshold. Once you're over that, then anything comes in.
I do say that, yes. Yes, I do say that. I mean, I would respect it's just one can see that is right from the advice.
Little a has got to be read against the general law that there must be a compelling public interest in expropriation.
Yes, the compelling case in the public interest test is in the circular. It's been held by the courts to satisfy essentially Human Rights Act requirements, but also it's actually found its way into the Planning Act 2008, and it is now a statutory test for compulsory purchases that take place within the context of that act. So, yes.
So then you come on to the question, what factors can be taken into account in evaluating the public interest?
Yes.
Then there's the swine flu example. Why is that not relevant?
Well, in my submission, it is relevant in the 226 context. What I was saying is that it wouldn't be relevant, I think, in a Section 70 context, but in a Section 226 context, it would be relevant. The decision maker would then have to decide how significant a factor they thought it was in the context of the order and the development which the order was going to facilitate as a whole. I mean, there's hundreds of considerations.
So is there any legal principle at all that can be formulated, or is it always going to be a matter for decision by the Secretary of State as to whether it's relevant, and if so, what weight to attach?
It's our submission that there is no need to create a legal formula, and the courts in the planning context have moved away from creating legal formulas, as we've seen in Tesco. But it's my submission that I appreciate it's the appellant's submission that a dividing line has to be drawn. I mean, in Monaghan, 2 of the judges didn't think it was necessary to draw a dividing line. The court didn't need to draw a dividing line. It was a matter, relevance and weight were matters for the decision maker, and it's my submission that that's the same here. I'm not offering, I'm afraid, a dividing line because it's our submission there doesn't need to be one.
Well, you've offered it must have something to do with the local authority's functions. So how pedantic are you going to be about that?
I don't think I'm going to be...
Well, the swine flu isn't a local authority function, it's an NHS function, for example. Now, used to be a local authority function.
But in my submission, my submission on that is that it would come in under 1A because it would facilitate. Not facilitate. It would contribute to the social well-being of the area. But may I say that maybe I'm wrong about that. But why is it necessary for the court to draw up some kind of dividing line? Why cannot it be left to the decision maker? armed with all the relevant facts and no doubt in that case statutory provisions.
Well, I think maybe we've taken this as far as we can. Mr. Katowski wants his time expert.
He needs his time, absolutely. I'm most grateful.
Yes. Mr. Williams.
Yes, I'm grateful. I largely adopt, although not entirely, the way in which my learned friend has formulated the points, particularly the latter point about related to the local authority's functions. I would not accept that restriction. I'll come to that shortly. My Lords, in my submission, this is an extremely straightforward case. This is all down to very basic public law principles. With that in mind, I have very little to say in addition in relation to the first issue in the case, which is the 1A point. The very little I do want to add in relation to that is as follows, and I just wonder whether the court would be so kind for the umpteenth time to turn it up. That's 1A in tab 1, because there are some important words in it which we have not, with great respect, paid any real attention to yet. And the important words are, if we have it, that the question which is raised, or the issue which is raised, is not whether the development in question is likely to contribute to, etc., but whether they think that. They think that is the acquiring authority, the local authority. It's good old public law. This provision would be very different if those words had been omitted, because then the provision would have set some form of test, if you like, in which it might very well have been for this court or courts below to have set some form of parameter. But the issue here is not, does this court or any of the courts below think that X is likely to contribute to Y? The issue here is one for the local authority's discretion, unless they think that. And that just brings in straightforward public law principles. It brings us to Wednesbury unreasonableness. It brings us to issues which are extremely well established. And the question then becomes not whether this court, with great respect, thinks that lines should be drawn in some particular place or not, whether this court thinks that it would have held these Royal Hospital site benefits to be ones which spring from the development of the RSS. The question instead is whether it was perverse of Wolverhampton to form the conclusion that they did.
Well, they've got to direct themselves correctly in law, haven't they?
They have, but that directs them to in my submission, to the statutory purpose of these provisions in relation to this first issue. The statutory purpose of these provisions is found not, as the appellant submits, in 1a exclusively, but in a combination of 1a and 1A. That is to say, the statutory purpose here is that land can be acquired to facilitate development in the overall best interests, if you like, of the authority's area. And the decision maker for that is, first of all, the authority that has the power here, Wolverhampton in this case. Then, of course, upon an objection being made, it's for the Secretary of State. But in each case, it is for the decision maker, first Wolverhampton, second, after an objection's made, the Secretary of State, to decide whether they think that the RSS development is likely to or not contribute to the achievement of those various matters. And so in my submission, I'll deal with this very briefly because it's adding little to my own friend's submissions. I just want to emphasise this provision builds in a discretionary power in the hands of the local authority. And the context, surely, therefore, must be that it's for this court, the courts below, with great respect, not to interfere or intervene in any judgment made unless the judgment made can be categorised as perverse. And no such claim is made here. It's explicitly disavowed that there's any claim that if this factor can be taken into account, there's no claim here that the weight that was given to it by the authority, decisive weight, was perverse. So, in relation to 1A, as I've said, the only points I want to add and draw out are statutory purposes, a combination of 1a and 1A, and that it's for the authority to decide whether it thinks A is likely to contribute to B. If it does, this court, the courts below, can only intervene if the decision was perverse. It's very, very simple public law. Moving on, because I wanted to spend most of my time on I would have said the second issue, but I do entirely see and accept the way in which my Lord Phillips put it, the second and third issue in this case. And that is assuming that this court decides, despite what's been submitted by my learned friend Mr. King and what I've just very briefly added, let us assume that it is decided by this court that the Royal Hospital site wellbeing benefits cannot be said to be benefits which fall within the scope of 1 capital A. Let's make that assumption. Now, in those circumstances, all that would have been decided, with great respect, is that it is not a precondition of the exercise of a 226 CPO power. It is not a precondition of the exercise of such a power that there must be benefits of the type that we're dealing with here, these wider benefits. You'll remember, I hope, Lord Justice Sullivan in the Court of Appeal saying that the benefits here were exactly the sort of benefits that the statute encourages authorities to look for. Let us assume that this court decides that's wrong, and these benefits just cannot fall within 1 capital A. That is by no means the end of the debate, obviously, because it brings you very quickly to the point that we won on in the High Court. Because in the High Court, we lost the 1 capital A argument. Mr. Justice Elias, applying very good public law principles, decided that it wasn't within the statutory words, but we then won on what was then the second issue, but perhaps in a more refined way would be the second and the third issues. And the second and the third issues, as I understand them, I'll just play them back. Issue number 2 would be whether, despite the consideration not falling within the mandatory precondition of subsection 1 capital A, whether nonetheless it can be taken into account in deciding whether to make a CPO, if you like, in any case where, forget the competition.
Once you've got your statutory precondition satisfied.
Exactly. Once you've got the statutory precondition satisfied, and here, no challenge, rightly, no challenge to the Tesco scheme satisfying 1 little a and 1 capital A, even on the appellant's approach, the question then becomes whether, when deciding whether to make a CPO in a normal, non-competitive situation, in a typical case, whether in those circumstances one is, if you like, debarred or prohibited from taking into account an offer of the type that's been made here, to which our answer is, of course not. And I'll explain why in a few moments' time. And issue number 3, obviously, gives rise to this particular aspect that we have in very, very unusual circumstances, indeed, of a competition between 2 rival big beasts, if you like, for 1 CPO, where only 1 CPO can be made. And again, the self-same question arises whether it can be said, as a matter of public law, that the authority is precluded, debarred, banned, cannot lawfully look at this offer in deciding between 1 rival proponent of a CPO and another. And our answer to both issue 2 and issue 3 is there is no public law principle that precludes that factor being taken into account. And the reason why I submit that is extremely straightforward. The only way in which the case could succeed against me, against the council and Tesco here, the interested party, in relation to issue 2 and issue 3, the only way in which the case could succeed against us would be if, as indeed the appellants submit and have submitted, if it is concluded that 1 little a and 1 capital A set the outer limits of all material considerations that can be taken into account in deciding whether to make a CPO. It is said in terms in the notice of appeal that these provisions prescribe the material considerations that can be taken into account in deciding whether to make a CPO. Complete nonsense, with great respect to my learned friend, Mr. Lockhart-Mummery. It is obvious that the provisions do not set out, and certainly do not, as a matter of reading them, prescribe the outer limits of what can and can't be taken into account. It's absolutely blindingly obvious. A very, very simple example, as we like examples, a very, very simple example, not an extreme one at all, will suffice to make good the submission I've just made. Forget a battle between Sainsbury's and Tesco, forget superstores serving local shoppers. Let us instead imagine a situation where whether on its own or whether in a rival competition situation, a party puts forward a development which would tick the boxes of one little a and one big A, and would benefit local people, but would also have regional or national benefits. What about the example of an internationally important headquarters offices? What about the example of an internationally important manufacturer? I mean, we as a country, UK PLC, have made decisions to get such people into this country in the past. What about an internationally important cultural institution like the Royal Opera House? Surely, if someone was saying to this local authority, we want to have this site CPO'd so that we can build this internationally important headquarters office, this internationally important factory, this internationally important opera house, it cannot be the case that the authority has to stop by law at the local wellbeing benefits.
But then there is some link or rational nexus with the proposed expropriation.
Well,
You're not really dealing with that argument at this stage.
no, I'm not, because I'm away from, with great respect, I'm away from rational nexus or otherwise, because my answer, great respect, my Lord Cummins, my answer to all such points is that there are, once you're into issue 2 and issue 3, there are no limits set by concepts such as a rational nexus, concepts such as what does a reasonable man know without any special knowledge, etc., because that's all one capital A. In the second and the third issues, it's my submission that there are no limits to potentially material considerations, save for the control by judicial review as to whether or not the weight that's been given to the point is perverse. Remembering the definition of perversity, it is, was it open to the authority, the decision-making authority, to give this degree of weight, whatever it might be, to this particular factor? And that's plenty sufficient to control all of this. Because obviously we can all come up with extreme examples. And if an authority, really went to some extreme that any of us would regard as being perverse, if you like, then judicial review would remedy that. But otherwise, it is for the authority to decide. And so, but the point of my submission, my Lord, was to make the obvious point that one capital A does not set the outer limits of the benefits that can be looked at. It is setting the minimum requirement, not the maximum that you can take into account. That's the point. Minimum, not maximum. And so in those circumstances, you can step outside what's said in one little a and one capital A, even in a situation where someone is promoting something solus on his own, not in a competition. Because if someone says, well, I want you to make this order, it's an internationally important development, it would put UK PLC on the map in this sector, it would do some good to local people because there'd be local jobs, so you get past one capital A, but it's the bigger arguments I want you to take into account. But of course the authority could take those points into account. Of course they could, even though they're not set down in the statutory provisions, because the statutory provisions are the tripwire, the minimum hurdle. They are not everything that one can look at in any given case. And so in those circumstances, in relation to particularly issue 3, as my Lord Phillips defined it earlier on, imagine a situation where there is a competition, as here. I ask, and I'll answer this in my own way in a few moments' time, what on earth can be said to offend any principle of public law in the authority faced with 2 rival contenders for one CPO, where the authority has to make a choice? What it could choose to say, a plague on all your houses, we're not making an order at all, but if it wants to make an order, it has to choose between the 2 rivals. What on earth is wrong as a matter of public law with the authority taking into account the additional benefits, good things, that one of the contenders puts forward? What on earth is wrong with that as a matter of public law? Nothing at all. It's all a matter of weight for the authority and the control on the authority's discretion to keep it within reasonable bounds is the control of judicial review principles. Is it perverse?
Mr. Kosky, the scenario I put to Mr. King earlier this afternoon, where you've got the 2 different sites, and it is at this stage not CPO, but planning permission, because there's only room for one. But you're going to have to make a CPO later in order to give effect to whichever one gets the planning permission.
I understand, my Lord.
And you've got Lord Phillips's illustration of one of them saying, I'll inoculate the borough.
This is in a planning, not compulsory purchase context.
Absolutely, but it's in otherwise the same. They both want to build a superstore on a site that they've got interest in, but not the whole thing. They're going to need a CPO eventually. But there it is, only room for one planning permission.
Could the authority just take into account that inoculation
You
as the...
concede not, because that, on any showing, surely, wouldn't you accept falls foul of the Tesco case?
Lord, I was going to say that I suspect that I would struggle to say that that would be a material planning consideration.
Well, if it hadn't been 20 or whatever it is, 4:05, I wouldn't have put it in quite so tendentious a way. But assume that you agree that...
Yeah.
So what happens, however, if it's not that, but it's an offer as here of development on another site. So it is to do with planning, at least. I mean, it is to do with planning. It's not to do with health.
Yes.
Any difference?
Well, my Lord, I would say all the time that, and my Lord might think, I'm not trying to evade answering the question, I will answer it directly, but I would say all the time the key is that this here is a decision to make a compulsory purchase order, not to grant a planning permission. So,
I know. Well, I haven't got to the planning permission yet.
You haven't got to the...
I haven't got to the CPO yet. I'm still at the planning permission stage.
So, my Lord, in this example, we have, sorry, I'm being a bit thick here, we have a situation where there are two sites and there are rival proposals still only for one planning permission.
Yeah, because there's only room for one superstore. So only one of them's going to get it.
Yes, my Lord, yes. And
so they both have applications. They're both, on the face of it, perfectly good superstores.
Yes,
here.
absolutely.
One of them's offering to do the fringe benefit, as I've called it.
And the fringe benefit here is...
As here.
RHS.
Oh, it's here. Oh, in that case, I am being extremely slow and stupid. In that case, my Lord, I would say that they would be perfectly entitled to take that into account. And I was...
Wouldn't fall foul of Tesco. You say Tesco would accept that because it would be a related external benefit.
I would say yes, and remembering that the provision is, in Tesco, Whitley, provision was, the line was drawn at something that has, if you like, nothing to do with. And the something to do with here is the connection made by the one...
The antithesis is between quite unconnected and related external benefit.
Yes, and I would say it's not quite unconnected.
I see.
That would be my submission, but...
Something to do with is surely understood there as a factor which has to be present before you can create the contractual link. The contractual link can't consist in, can't make it something to do with.
Well, this is where, with great respect, I think we might just benefit from a moment or two looking at two statutory provisions which are very important to this case. One, the statutory provision under which the link is actually made here, and secondly, section 106 itself, because there's an aspect of 106 and I think we haven't quite focused on yet. So can I just do that very quickly? But I would say all the time, in response to my Lord Brown, even if there's something in the planning field which crosses a line, that does not answer whether you can take it into account in the CPO field. Because I do.
You say, even if you're wrong on the last answer,
absolutely.
And even if Tesco would say you couldn't for the plan, once you've got your plan,
yes,
you
as
say,
here.
Then but then you say you could take account of it at the CPO stage.
Absolutely, because they are two different fields with different statutory provisions. And it is a non sequitur to say that if it's relevant in planning, it's relevant in the CPO and not vice, if not relevant in planning, it can't be relevant in the CPO. Why? There's no reason why at all. Can I just very briefly deal with section 106? It's at tab 11 in the Authorities Volume 1. And so far, I believe, when issues have been raised during the course of the proceedings about a 106 planning obligation, I suspect that it's being thought of in terms of 106 planning obligation attaching to the Raglan Street site. That, for example, as was said, I think yesterday, the store on the Raglan Street site can't open unless and until the Royal Hospital site has been done up or whatever, it might be restored. We just need to look at 106 as just another way in which this will be done, which might just throw that simple assumption off balance a bit. So 106 subsection 1, any person interested in land, etc., can, by agreement or otherwise, so you can do this either agreeing with the local authority or just offering it in a unilateral way, put forward a planning obligation, A, restricting development or use of the land, B, requiring specified operations on or under or over the land, C, requiring land to be used in a specified way, or D, requiring a sum or sums to be paid to the authority. Sub 2, a planning obligation may A, be unconditional or subject to conditions. I think we can stop there for my purposes. Now, very briefly indeed, if a party had a sufficient interest in the Raglan Street site to enter into a Section 106 planning obligation, it could obviously say, we intend to build a superstore on the Raglan Street site under 106.1 A, we will restrict that development by saying we won't open that store unless and until we have done some work somewhere else, restoring the Royal Hospital site, because that would be a combination of 106.1A and 2A. It would be a condition imposed on and a restriction imposed on that development. That would all be fine, and I think, and I suspect, is the example we've all had in mind, or many of us have had in mind during the course of these proceedings.
Can you speak up a little? It's quite a big
so
call.
sorry.
No, it's quite a big call.
Would it be? I mean, you say it'd be subject to conditions.
Yes.
You can impose, can you, a completely unrelated condition? Has nothing to do with the site, whatever.
Absolutely. Well,
Yeah.
Yes. I'm so sorry for not speaking up. In relation to the other completely different way in which this could be done, Tesco owns a Royal Hospital site, as we know. It could now put forward a 106 planning obligation. It doesn't have to be connected with any development proposed at all, but it could now say, we oblige ourselves to restore and refurbish the Royal Hospital site to bring it to beneficial use. That would be under Section 106 sub 1, subject to the condition, under subsection 2A, subject to the condition that that obligation will arise if, as and when, we have built a store on the Raglan Street site and are ready to open it. You could do it that way. So the obligation doesn't have to relate to Raglan Street directly at all. It could have been here. This is one thing we could have done. We didn't do it like this. We went a completely different way, as I'll explain in a moment. But we could have said, we own Royal Hospital, we would do all these wonderful works to it, and the precondition of us doing those works is that we've built a store at Raglan Street and are about to open it. We can't open it until we've done all these works. Entirely within the scope of 106. Very, very important passage in Lord Hoffman's speech in the Tesco case. The legality of a Section 106 planning obligation has nothing to do with the Newbury tests at all. The legality of a planning obligation depends entirely on the terms of the section.
Which bit? Page?
That's in Tesco at 686, and it is just below C.
Yep.
I know a friend, I think, read before and after, and I was itching in my seat from a learned friend to read the sentence in the middle. The varieties of planning obligations depends entirely upon the terms of Section 106. So, had we gone either of those routes, there could have been a lawful deed obliging us to do something at the Royal Hospital site. Had we gone either by putting an obligation on the RSS site or by putting an obligation on the RHS site, in either of those situations, we could have entirely lawfully created this obligation upon ourselves. In fact, as it happens, in agreement with the local authority, we've gone a different route. We've gone the Section 233 route, which I don't think we've actually looked at. If we have, I've forgotten when, it's tab 12 of the bundle, and interesting to see its terms, I would suggest. Um, 233, this is the section that's been utilised both for the 2009 agreement that was entered into shortly before the Court of Appeal hearing, and also was useful for its predecessor, the 2005 agreement that was in place even before the resolution was made in this case. So this isn't news, it's been known for years. Section 233, subsection 1, where any land has been acquired or appropriated by a local authority for planning purposes, it's for the time being held for them for the purpose for which it's so acquired or appropriated, the authority may dispose of the land to such person in such manner, subject to such conditions as appear to them to be expedient in order, and it's then this. A, to secure the best use of that's the land they're selling, or other land, etc., etc. And that's the provision that's been used here. The other land is a Royal Hospital. We are being sold, once the site is assembled, the council, if this all goes ahead, will sell us the Raglan Street site. We're going to have to indemnify them, obviously, for all the compulsory purchase compensation. They will sell the land to us, that's the deed. And the why? Because that will secure not only the best use as it happens of the Bragdon Street, but also, and most importantly, the best use of the Royal Hospital. That's the way this is all done. And so if we just stop and think about the consequences of the appellant's case here, think about it with great respect in this way. Imagine that here the authority has indeed compulsory purchased the site from Sainsbury's. Imagine it wasn't anything to do with the competition, nothing to do with that. They CPO'd it for Sainsbury's own development. And then Sainsbury's pulled out, just as they did in the past when they were literally about to sign on the dotted line to sell the site to us. Sainsbury's then have a change of heart and pull out. In those circumstances, the authority, having acquired the land under 233, can then sell it to someone else, for example to Tesco, not so as to bring about the best use of the Raglan Street site, the site they're selling, but so as to bring about the best use of other land, here the Royal Hospital. That would be entirely lawful. And yet on the appellant's case, although the authority, once they've got their hands on the site, can sell it to trigger good things elsewhere, cannot acquire it in the first place to try to bring about good things elsewhere, as well as on the site itself. How can that be? I would suggest.
Presumably because at the first stage, they're disposing of their own property, and at the other stage, they're acquiring compulsory somebody else's property.
But the underlying purpose of this provision, 233, acquisition and appropriation of land for planning purposes in Part 9, the underlying purpose of all of this, as one can see, is to try to bring about the best use in the public interest of land in the authority's area. It is, with respect, important, what I'm trying to submit is it's important not to simply think in terms of 106 and planning decisions and planning obligations. As it so happens, there's another provision here, which is the one that has been relied on to date.
I don't think it gets a mention, or am I wrong in your stated case?
233, yes, it does. Yes,
does it?
Yes, it does.
Well,
yes. In our case, most certainly, yes.
I've
yes.
missed it. Well, sorry, I don't want to spend time on it. Just
not at all. Not at all.
Junior would just tell you.
My Leonard Junior will
tell me where.
Probably prove that what I've just said is wrong, but I'm sure we refer to it because, of course, we refer to the Scottish case, the name of which I can't remember off the top of my head. Commercial, whatever it's called.
Well, you refer to that at page 9.
Paragraph 31, it's mentioned.
230, quite right, 31. Thank you so much.
31, oh yes, here you are. Yes, excellent.
Thank you very much.
Yes. So, there's nothing new in this world, certainly nothing new in the case anyway. Thank heavens. So there we are. The point that I'm seeking to make is that what I'm trying to submit is as follows. What faced the local authority in this case was a stage 3 case, as in my Lord Phillips' categorisation. Each scheme ticked all the boxes under the statute. Let's assume the additional benefits at Royal Hospital don't fall within the precondition of 1 capital A. It's a competition, so it's a stage 3 example. And we have a situation where the authority knows that the consequence of deciding in one way is that through a perfectly legal, lawful deed, some further good things will result for its inhabitants. It knows, if it chooses to exercise its powers to choose the other developer, that some perfectly good things will happen on one site, but not on 2 sites. So it knows that the consequence of its action going one way is that 2 sites are developed and restored. If it goes the other way, only 1 site is. What principle of public law precludes the authority from taking into account that the lawful consequence of choosing to go one way rather than the other is that additional good things will result for its residents at 2 sites rather than at 1 site? Answer by answer. There is no principle of public law that prohibits, inhibits, bans the local authority from taking into account the perfectly lawful consequences of choosing to act one way rather than another under these provisions. And that is probably the top and the bottom of what I wish to submit on the main points, very, very briefly indeed. And if I can just be given 1 moment. Language.
You say that doesn't conflict with what Lord Keith says at 677A to be?
My lord, give me one moment. I'm so sorry.
677, you seem to be using the pagination of the bundle, not
Yes, of course.
A to B. I mean, an offered planning obligation which has nothing to do with... I appreciate this is planning, that case is planning on your CPO, but...
Yes.
I mean, if it was planning, yes or no?
Well, my lord, I've already, have I not? I
Yes.
believe I've already said yes to that. But even if the answer is no, it doesn't matter.
Okay.
That's my point. Particularly and especially when one is in this stage 3 situation where there is a choice that has to be made, not in the planning field, because that's all done and dusted. It's all done. Both have got their permissions or thereabouts. This is in the compulsory purchase. Who am I going to back by acquiring a share of the site to get away the development in question? Who am I going to back? Why should I not be allowed to take into account benefits which are secured in an entirely lawful legal mechanism, here under 233, but it could just as well have been under 106 related to the RHS or the RSS site. I just very, very briefly wanted to finish by, and I'm sorry for taking so much time, but to finish by saying a very few words in submission about auctions, inducements, and so on and so forth. With great respect, in any competition for a compulsory purchase, there is bound to be some form of, in inverted commas, auction. If the word is used purgatively, then I take exception to it, obviously on my client's behalf. But the reality is that in any competition, each rival contender is going to be trying to outbid the other. And take the example that was given by my Lord Collins yesterday of housing developers. Say, forget the big beasts of the retail world. Imagine these were two rival housing developers fighting over this site. Planning policies for every area in the country lay down an amount of affordable housing that each scheme has to provide. I don't know what the percentage is. Let's assume here that the requirement was 30% of the houses have to be affordable. It doesn't matter what the figure is. Each of the rival schemes has 30% affordable housing. Therefore, it can't be refused permission for not having enough affordable housing. When it comes to a battle between those two at CPO stage, of course it's open to one of the rivals to say, I will provide more affordable housing than I can be obliged to provide on the site itself. So someone could say, I'll do 40, and the other person could say, I'll do 50, and so on and so forth. But why couldn't one of them say, not only will I do, say, 30, 40% on the site in question, but I own another site across the road, across on the other side of the town. Who cares where it is? It doesn't matter. Proximity has nothing to do with it. Why can't the authority take into account an offer from one of those rivals to say, I'll also do the equivalent of 10% or 20% on this other site that I own? Because I will make so much money out of doing the scheme on the site in question, I can afford to be more generous in the public interest than otherwise, if I can get my chance to make my profit in the first place. And I only make my profit if I can get the compulsory purchase. And in those circumstances, of course, it makes sense for the developer, it makes sense for the public good to try to achieve the best overall deal, if you like, the best overall package that one can. And I simply don't understand how it can be said that offers of that nature have to stop at the site boundary, whether one artificially draws a red line around 2 or 3 sites as one can, or whether one doesn't. What does it matter? The consideration is there a public law principle that prohibits this matter being taken into account? Answer, no. And finally, then, in relation to this particular case here, there was my Lord Phillips used the expression inducement at the end of yesterday's hearing, and I hope that I had wanted to actually start with this, but I'll finish with it instead. I hope it's extremely plain from what's happened here. It's absolutely blindingly obvious that there was a race between Sainsbury's and Tesco. Sainsbury's own 85% or whatever it is of the site, and we own 15%. They can't do anything without us, we can't do anything without them. But there's more of their land that has to be bought than the other way around. The schemes themselves were pretty even Stevens. There was very little to choose between them. Doubtless my clients would want to extol the virtues of their scheme over Sainsbury's and vice versa, but the council said nothing much to choose. In that situation, it fell to Tesco to either say, well, we'll leave it to the merits of the 2 individual schemes, or for them to try to find some aspect which allowed us to pip Sainsbury's in this race, because that's what it was. And we put forward this other site that we own, where a viable scheme has not been capable of being found even at the peak of the economic boom, so it's a liability to us. We put forward taking some of the profit that we would make from a store on the RSS site as a means, some of the profit, not all of it, some of that profit, as a means of doing up and restoring the RHS site. It's good for Tesco because it gives us a superstore in Wolverhampton that we otherwise won't have. So the choice is no profit or less profit than if we didn't have to give up some of it for the RHS. So we get money out of the Raglan Street site. It's good for Tesco because it allows us to bring forward a completely unviable Albatross, the Royal Hospital site, and actually use some of the profit from the superstore to do up the Royal Hospital site. It's great for us, great for our shareholders. This has been all the way to the board. It's great for our shareholders, but it's also good for the public of Wolverhampton because they get two significant benefits rather than just one. Why should the local authority be prohibited from taking into account that here in this happy coincidence of private commercial best interests and public best interests, why can't the local authority take into account those extra benefits they get by choosing to go one way rather than the other? It's, from our point of view, it's entirely commercial. Our shareholders doubtless be extremely happy indeed to be making money out of a store in Wolverhampton, even if that's at the price of having to give up some of that money to restore a site which has proven to be a liability for them. That's great for our shareholders. It's also very good for the public interest. Those are the submissions I wanted to make. Unless I can be of any further help or hindrance, those are the points I want to put.
Mr. Linus. Yes, Mr. Lockhart, Mummery.
I'm going to be extremely brief.
Yes.
I'm not going to be 3 minutes. I take it I have a little leeway beyond that.
A little. But I say for myself that the last point is the one that I would really welcome assistance with. The issue 3.
Yes, my Lord, yes. My Lord, I'm going to focus on just 3 or 4 what I regard as the most important points that have arisen, and that point will come within it. My Lord, the first matter I want to raise is this. There's been much merging, I would suggest, in the submissions, particularly of my learned friend Mr. King, of the two different concepts of the materiality of a consideration and the weight to be given to it. And he emphasised the merger, effectively, of those issues by his reference to some of the financial cases in the field of planning permission, Sosmo Trust, Sovmots, and so forth. But there is, of course, the clearest dividing line between the two that arises in this appeal as it arises on many planning and public law cases. And, my Lord, it can be seen at its most clear, happily in a planning context, at tab 30 of the authorities, which is the Tesco case. Page 687. Paragraph 13, materiality and planning merits. It would be inappropriate for me to rehearse the reasoning in Plymouth, but I shall, if I may, look at the question from a slightly different perspective. The law has always made a clear distinction between the question of whether something is a material consideration and the weight it should be given. The former is a question of law, and the latter is a question of planning judgment, which is entirely a matter for the planning authority. Provided that the planning authority has regard to all material considerations, it is at liberty, provided it's not Wednesbury unreasonable, to give them whatever weight the planning authority thinks fit, or no weight at all. The fact that the law regards something as a material consideration, therefore, involves no view about the part, if any, which it should play in the decision-making process. And so, my Lords, in this case, the issue is, which of course why we are in this court in the first place, one of law. The issue is the extraneous matter at the RHS, as we would and have submitted, is that a material consideration for the purposes of the exercise of the powers under section 226. A matter of law for the court to decide. Not a material consideration, plainly, that's the end of the matter. If it is a material consideration, then consistent with essential principles, well-known principles, the authority can give it as much weight as it wishes, and we see that in this case, whereby the material consideration, the immaterial consideration, was given precisely. So one sees this very clearly playing in this case. Lord, the second matter I wish to come to, I think it's the second matter, my Lord, is, I think, responding to my Lord Phillips just now, and it arose out of my Lord analysing the issues in this case in three stages, or three issues, my Lord will recall. First stage, or first issue, is it within, is the RMS within one capital A? Well, that is on all fours with issue 1 in the appeal, and indeed is an issue. Stage 2 of my Lord was, if not, can it be part of the exercise of the discretion under section 226? And my Lord, again, I take no concern about that. That is issue 2 in the appeal. My Lord's third stage was, if we have two competing developers or developments, do these matters then become material considerations? And my Lord followed them up later today with the suggestion that at that stage, and to quote my Lord, section 226 goes out of the picture. Well, Lord, I do not respectfully accept that there is this third stage. Of course, there will be cases of mere competition at an early stage of the compulsory purchase order in a lot of cases, and there will be cases where the authority has to choose between two competing developers. Take a frequent example, the authority conceive of a town centre redevelopment scheme that would benefit their area. They perhaps own most of the site, lots of leaseholds in other ownerships. They need land assembly, and they need to produce, or somebody to produce a viable and attractive scheme that will deliver their objectives. So they put the matter out to tender, as you say, and developers make bids. Land Securities comes in with a development proposal and a whole lot of benefits that it will bring with those proposals. Hammerson, as I say, come in with an alternative form of development, and either less inducements or more inducements, as the case may be. Now, Lord, at that stage of choosing, as it were, in that competitive environment, that would be a non-statutory decision, and provided the authority acted in accordance with their very widest powers in the Local Government Act, that in the vast majority of cases would not be a justiciable decision made outside the statute. But, my Lord, all that has to be focused into section 226 when the decision to make a compulsory purchase order is made. And, my Lord, that is this case. And it is at that stage, of course, that the focus has to be exclusively on the terms of the statute, namely section 226, the express terms, and the material considerations which I made my submissions about yesterday, that flow, I suggest clearly from those terms of the statute. My Lord, this case is not a stage 3 case in reality, and my Lord, I took the court yesterday anticipating this point to the terms of the report. I made some submissions yesterday dealing with competition in terms, and I drew the Court's attention to tab 20. And I know the Court is well familiar with this, but if I can look, for example, at page 281, as I did yesterday, it is headed referencing the making of a compulsory purchase order in principle to support food support development of the site. The purpose of the report to recommend to members a decision concerning the making of a compulsory purchase order on land at Dragon Street. The report sets out the considerations exclusively within the terms of section 226. It's set out section 226 at page 283. That is the decision that is made. The report has, of course, in our submission, one significant and major error that found its appeal, namely the bringing into account the RHS in the manner it did. And the decision, my Lord, which we see in the recommendation, for convenience using the same document, in page 279, is expressed wholly and correctly, albeit they made an error, in terms of section 226. That is the decision that has been made. That is the decision that's under review. And Lord, I would respectfully resist any suggestion that there is, as it were, a non-statutory third stage, by which route, on my friend's submissions, we frankly have a free-for-all. We have the swine flu example, which is, with respect, a very helpful way of testing the matter, and the other examples that were given. They are wholly outside the purpose of the section, which is to acquire land or development in the public interest and promote a compelling case in the public interest for the development that is to be facilitated. So the third topic I must deal with, incidentally, before I do that, can I just deal with a purely administrative point? I'm sure the Court is aware of this, but it wouldn't be for the way that I have presented the documents. My Lord, at page tab 20 of the core volume of the appendix, I prefer, and nobody's, as it were, qualified this, referred to the letter that was sent to Sainsbury's and recorded what the resolution was. My Lord, I refer to that in the interest of brevity and finding one document. In your Lordship's judgments, you will no doubt wish to, for the sake of accuracy, refer to the resolution itself, which is tab 21. There's no difference in the wording, just a presentation of various articles, and it would be obviously desirable for the Court to have before it the precise terms of the resolution, page 383.
Same date.
Same date. Well,
Yes.
And the substance is identical. It's just a formatting, and it would be undesirable if the Court's decision were based on a letter, as it were, rather than the true meaning. Forgive me again that way. That was important. Just to deal with. The third topic of substance, I wish to deal with, is to respond, I hope, briefly on the planning cases.
Can I just, before you go to them, how are you going to respond to the point made about wider considerations by Mr. Katkowski? He said a local authority must be entitled to lift up its eyes onto the sky and say that this is a particularly desirable use. We will compulsorily purchase because it will be a flagship opera house for the whole country, or flagship building, music hall or whatever for the whole country. And how do you bring that within what I think you say must be factors relevant to the achievement of the statutory purpose of facilitating the particular development on or in relation to the land?
With, I hope, no difficulty at all, that submission doesn't advance the scope of the section whatever. The test, the purpose of the section is there a public interest in a compelling case in acquiring land to facilitate the carrying out of development, and for there to be a case of the public interest to make this form of intervention, plainly that development must be desirable, it must be in the public interest, there must be a compelling case. And well, certainly, if one had a development that has benefits beyond the authority's boundaries, well and good. Well and good. It simply goes to the quality of the development that you're carrying out and the benefits of that development, and would raise the compelling case in the public interest beyond, as it were, the purely local to the cross-boundary area, perhaps national. Doesn't advance the terms of the debate, in my perspective.
You're saying you're still looking at the development rather than some other development.
Absolutely. Absolutely. My Lord, can I go very briefly to the two significant planning cases that were dealt with this afternoon. One is Plymouth at tab 25 and one is Tesco at tab 30. I appreciate time is limited. My Lord, I can do no more, I think, than invite the court, as my friends did, to read these decisions. I would just highlight, if I may, from Plymouth tab 25.
24, actually.
I beg your pardon. I'm so sorry. I've pulled it out separately and made an error. I do beg your pardon. Plymouth. Lord, the headnote repays reading. I will not read it. I just emphasise page 496 in the judgment, I think, of Lord Justice Hoffman, as he was. In the last complete paragraph, page 496, starting, I therefore reject, His Lordship is rejecting Mr. Gilbart's submission of necessity. He says in the fourth line, they, that's to say the matters proposed, were all considerations of a planning nature, and the only question is whether they fairly and reasonably related to the development. And that is the basis of that decision. On analysis of the facts and the advice of the planning officer in that case, the matters fairly and reasonably related to the development and therefore fell within the highest authority. Tesco, if I've got it right this time, tab 30. Yes. My Lord, again, I ask that the headnote be read, and it's interesting. It's no substitute for the speeches, of course, but at page 6667, material considerations to which regard should be had under section 70 if it was relevant to the development, wait for the decision maker. Accordingly, Tesco's offer for funding the link road is sufficiently related to the proposed development to constitute a material consideration. My Lord, page 682, if I may. in the speech of Lord Hoffman. Particularly helpful here, I respectfully suggest, because his lordship is focusing so clearly on the statutory test. He sets out part of the circular. He says in line 5, the need for a relationship to development flows from the requirements of what is now section 72 of the Act, which he quotes, a benefit unrelated to the development would not be a material consideration, and a refusal based on the developer's unwillingness to provide such a benefit would therefore be unlawful. And the Lord, plainly, as the court has, it's our submission that in the planning context, and of course that context is not before the court to decide as such, but it happens that in the planning context, the RHS would be an unrelated benefit. That was how the matter was advised to the committee. It was accepted by Tesco and didn't feature at all in the grant of planning permission at the RSS. My Lord, even if one were to take, which of course one must, page 677 from the speech of Lord Keith, and this is a point that I think my Lord Mance touched on, at A to C, an offered planning obligation which has nothing to do with the proposed development will not be a material consideration, but will be buying the planning permission. If it has some connection with the proposed development which is not de minimis, then regard must be had to it. That plainly must be all read in the context of the overriding constraint that all material considerations must relate to the development being permitted. But, my Lord, even on the slightly laxer expression, if I may say that, of Lord P, nothing to do, we say quite roundly, in the terms of the statute, whether section 70 or 226, RHS has nothing to do with the RSS, apart from its voluntary contractual relationship. Those were the essential points I wanted to make, unless I insist.
No, thank you very much. The court is grateful to counsel for their submissions and will reserve its judgment.